Good evening, I'm Pinky Webb. Tonight we ask the questions, we tackle the issues, we clarify matters, and we get on point. Senator Risa Hontiveros sought the help of the National Bureau of Investigation to initiate probe and prosecution of people behind the creation of YouTube and Facebook accounts under the name Pagtanggol Valiente. Included in the cyber libel complaint is Michael Maurilio in connection with his alleged defamatory statements in a video uploaded on the social media accounts. In the video, he stated that Hontiveros paid him 1 million pesos to fabricate testimony against Kingdom of Jesus Christ leader Apollo Quiboloy, former President Rodrigo Duterte, and former Davao City Mayor and now Vice President Sara Duterte. Let's get on point with one of the legal counsels of Quiboloy, Attorney Ferdinand Topacio. Attorney Topacio, thank you so much for your time. Good to see you.
Welcome yes, always good to see the most beautiful woman on air.
Thank you, sir. All right, umpisahan na po natin dito kay Michael Maurilio. I know you know the story. So,
yes.
He claims now that the Senator Risa Hontiveros, paid him 1 million pesos basically to speak ill of the KOJC leader. What are your thoughts on this?
I do not know Mr. Murillo. I think he's the one who goes by the moniker alias Rene, if I'm not mistaken. But if he is saying that, it would not be the first time that there would be an accusation of witness tampering and subornation of perjury against Senator Risa Hontiveros. Because I personally know of 2 incidents wherein the same manner of accusation was made against Senator Hontiveros.
Tell us more about that.
I think Jing Paras, who was a guest in one of your shows here, gave a gist of what happened. This was during the time of the controversy surrounding Kian de los Santos, who was killed by the police in a supposed rub-out. And while I believe that the policemen involved there were rightfully punished for their crime, it does not detract from the fact that with respect to certain witnesses who were of minor age at the time, Senator Hontiveros intervened by getting them from the custody of their lawful parents and bringing them somewhere else. As a result of which, the father of one of those children approached us in the Volunteers Against Crime and Corruption under then Dante Jimenez. And Dante Jimenez assigned me as the chief legal counsel at the time of the VACC, and former Congressman Jing Paras, who is one of our volunteer lawyers, to take care of the problem, and we brought the matter to the attention of the CIDG. And the CIDG, after investigating it, sent operatives to the Senate to talk to Senator Risa Hontiveros. At the time, her staff said that she was not in, although Senate security confided to us that she was in her office. And the second would be with respect to the Farmally case, where a certain Mark Clarence said on video, on record, that he was bribed by Senator Hontiveros with electric bikes and certain amounts of money to testify falsely against executives of Farmally. And we still have the sworn statement of that person. We still have his video. And as a result of these 2 incidents, a case for kidnapping and an ombudsman case was filed against Senator Risa Hontiveros. So probably...
And what is the status of that?
We have not been informed of the status, but if Senator Hontiveros has filed the case, maybe it was because of her experience with these 2 cases that she decided to preempt the filing of cases against her by filing her own case.
So does that mean to say that you believe this Michael Maurilio?
I reserve my judgment. However, there are 2 points that I wish to raise. Number 1, these allegations are serious and deserve the investigation not only of the police authorities, the NBI, but the Senate itself by its ethics committee, because, as I've said, this is not the first time that Senator Risa Hontiveros was accused of these things. Number 2, Risa Hontiveros, being a public official, should not be, well, to use the shop-worn phrase, she should not be onion-skinned, because a public official, by entering public service, holds herself out to a higher standard of conduct and should expect the public to scrutinize her behavior. That's why, with respect to libel and cyber libel, the usual presumption of malice does not apply when you're a public official. Instead, it is the public official who must prove malice on the part of the person alleged to have libeled her in order to secure a conviction.
Does it mean, attorney, that what the senator did the other day, going to the NBI, and basically, to be very clear about it, is to initiate the investigation and the prosecution of the persons responsible for the creation and management of this Pagtanggol Valiente, as well as Michael Maurilio and others? Do you think that was being onion-skinned of her? Because I do recall when she was being interviewed by the media, she says that, this is part of her job, mangyayari siguro yung mga ganitong klase. Pero yung pwede, you can call her out on certain things, basically rewording it. But when you lie or when you tamper with the witnesses, that's a different story, and that's something na hindi niya palalampasin.
That's what I said during my TikTok interview earlier. She is well within her rights.
Okay.
However, she must expect that because I do not believe that one person, as I've said, I'm reserving my judgment on this alias Rene. But I do not believe such a person or the other persons who previously made allegations against her would have the courage to make baseless allegations considering how powerful and influential Ms. Ontiveros is. So I think instead of investigating whether there was a lying here or whatever, the investigation should cover everything. The NBI should investigate not only whether or not this witness was lying, but whether or not there is truth to his allegations in order to make it fair.
Both sides.
Yes, both sides.
All right. Do you think, you were saying a while ago that this is a serious matter. Before we go to what you were saying, that there should be an ethics complaint filed against her regarding this. It's serious because meron pong witness na nagsabing may problema ang KOJC, na kinawawa siya, naabuso siya, etc. And then, bumaliktad at sinabi na pinilit lang siya ng supposed to be ni Senator Risa na sabihin ito. But with regards to Senator Risa Ontiveros' defense when she was talking to media, kasi nakita yung parang pagkadismaya at galit niya. Meron ho kasi siya, attorney, ng mga resibo. In fact, her office had shown that this man, this individual, supposedly emailed them back in 2023. He left KOJC around 2021, the year 2021. They did not respond immediately, to which Michael Maurilio had reached out to them 2 more times. And then he even asked at some point for a laptop dahil para daw magkaroon siya ng trabaho, to which the senator's office said they don't really give out such monetary or even laptops for that matter, kasi ayaw niyang magkaroon ng misconception doon sa kung magbigay man ng laptop or kahit na anong tulong dito sa witness. Let's just stop there first because there are more. Yun pa lang, what do you think about that? Because from a laptop na ayaw ibigay ng office ni Senator Risa to him being paid 1 million pesos, supposedly.
As I said, judgment has to be reserved on that. But that is why I'm calling on the NBI to investigate not only from the point of view of Senator Ontiveros that this person is lying, but from the point of view of the person as to whether or not there was pecuniary exchanges made in exchange for his testimony. Because that is also allegations. There were also allegations made against Senator Ontiveros in law that proves a pattern. So that is part of a pattern of events that strengthens the possibility that a present action was done on the basis of previous actions. And that is admissible in court, actually.
Okay. Attorney, but when you look at the series of events that supposed to be happened, there was also in February 2024, this individual said he was being convinced, allegedly, by some acquaintances in the KOJC to recant his previous testimony. And then in June 2022 and 2025, he messaged supposedly that he was abducted. Kinidnap ako at tinatakot ako. Dito ako kinulong sa Glory Mountain. Help me please. To which the office of the senator forwarded this to PNP Davao. And then the video. I know that, I guess what I'm trying to understand here or try to get from you is, while you're saying there could be a pattern because there were previous supposed to be incidents, when you hear something like this na merong resibo at may maipapakita po, does that show that the witness is not believable or not credible?
These are matters that are addressed to the investigator. We have to take the overall context of these things because, remember, witnesses recant all the time. In the case of Senator De Lima, the witnesses recanted. There were documents that point to the fact before that the first testimonies pointing to Senator De Lima as the person behind the so-called Bilibid drug trade, these testimonies seem to have been given voluntarily. But later on, they recanted, and the court believed the recantation. So I'm not saying the recantation of alias Rene is believable or not. All I'm saying is that based on previous pattern and based on the surrounding circumstances, there may be more to this that meets the eye. All I'm saying is that I am interested in the truth of this. And now, with respect to the ethics complaint, there is something wrong, not only because there is this recantation, but because money may have changed hands with respect to testimony. That is why, if I recall correctly, then Secretary Vitaliano Aguirre also filed an ethics complaint against Senator Ontiveros for violating the Anti-Wiretapping Act. And this case, this violation of the Anti-Wiretapping Act is still pending, if I'm not mistaken, before the Pasay City RTC. So there is this pattern that, as I was saying, deserves more serious consideration and a much closer look.
So with regards to this ethics complaint, who do you think should file it?
Any senator may file, actually any private citizen may file, or any person affected by the testimony. Remember that I filed an ethics complaint against then Congressman Dan Fernandez for violating the rights of my client and for trying to embarrass me in front of media and that August chamber. So any person affected may file before the committee.
But because you're one of the lawyers of Apollo Quiboloy, Pastor Apollo Quiboloy, do you think that your group, your team, or somebody from your team should file an ethics complaint?
I have suggested as much to the team, but of course, our team leader is Attorney Torreon, and I will leave it up to him. I leave it to his sound discretion.
How important is it for your group or your team to reach out, or has anyone reached out to this Michael Maurilio?
Not, as far as I know, none of us. It appears to have been spontaneous, but of course, if someone who recants, let us be candid here. If there is a witness who is doing an act that is favorable to your client, it is natural to extend help and assistance to that particular witness.
Of course. Hence the question, has anyone reached out?
Well, from my point of view, from where I'm sitting, I have no knowledge, but I would not be surprised, of course. It would be the natural thing to do for a lawyer.
All right. And you are also the lawyer of former Congressman Arnulfo Teves, and recently you were given this new job. You are the spokesperson for the PDP Laban with regards to the impeachment complaint against Vice President Sara Duterte. That's right.
Yes, that's right. They could not find any other person who was willing to work long hours without pay.
We're going to talk about that after the break. We'll be right back with Attorney Ferdinand Topacio. Stay tuned. This is On Point. You're watching On Point, still with us, Attorney Ferdinand Topacio. First, let's talk about the impeachment complaint against Vice President Sara Duterte. So you're the spokesperson for the PDP with regard to the impeachment on the Vice President. Well, is there anything that the PDP is doing with regards to the impeachment complaint?
With respect to the impeachment complaint, the PDP, as an old party and one of the major parties in the opposition thought it would be proper for it to be heard on a matter of national interest that may have serious legal and political repercussions in the national life. So that's why they appointed a spokesman. We have a general spokesman in the person of Attorney Raul Ambino, of course, who has been doing a fantastic job. But they saw the need for someone who would be laser focused on this single issue alone.
And what exactly are you doing now as the spokesperson for the impeachment complaint for PDP? Because right now, from my understanding, the Senate impeachment court is still waiting for the second certification from the House prosecution panel with regards to, well, number one, they already did the certification on the one-year bar that they did not violate that. And the second is supposed to be that the 20th Congress is willing to pursue what the 19th Congress did. Yun po yung hinihintay supposed to be ng
Yes, ma'am.
impeachment court now. Okay.
So, well, they want the PDP to articulate its sentiments on the ongoing trial proceedings before the Senate. Our stand on the matter is quite simple. Number one, that there was a violation of the one-year ban. I believe this issue had already been raised last February 18 before the Supreme Court, but there is no action yet. And number two, that under the terms of the fundamental charter or the Constitution, such an impeachment complaint should not survive the transition from the 19th to the 20th Congress. And we are issuing statements in support of that because historical experience shows us that in the last two impeachment complaints, they radically changed the course of our nation's history. In the case of Erap Estrada, it triggered another people power revolution, so to speak. In the case of CJ Corona, the country was not only divided, it was not only later demonstrated to be a case of persecution because he was practically exonerated when he was restored to his full privileges post-mortem or posthumously by the Supreme Court. But it also triggered a domino effect with respect to the removal of CJ Sereno. So we believe that by contributing to the national debate, we exhibit fealty to what the late Justice Oliver Wendell Holmes of the U.S. Supreme Court said, that the ultimate good desired is better reached in the free trade of ideas.
Are you saying, in a way, because of the past experiences that you had mentioned historically in the Philippines of impeachment cases, that there's nothing good about impeachment cases and trying them?
No, I would not say that. In fact, the process of impeachment or the mechanism of impeachment is an integral part of the transparency and accountability provisions of the Constitution. But then, impeachment is a two-edged sword. It can cut for good or for evil. If used to enforce transparency, if used to curb corruption, if used to address abuses in official functions, then it is very useful. But when it is used as a blunt instrument for political persecution or political assassination, then that is when the trouble begins.
And then you have the two sides actually saying that. You have the Vice President basically saying this is being used for political persecution because I'm a front runner for the 2028 elections. And then you have the House prosecution panel who's talking about accountability, taking officials to hold to public account, right? Because of supposedly what they had discovered on confidential funds, etc. So it's a two-edged sword, and you don't know actually which one, anong mananaig dun sa dalawa.
Well, para sa akin, if you're going to talk of transparency and accountability, you cannot be hypocritical. What is sauce for the goose should be sauce for the gander. If you're talking about confidential funds, the DOJ has $500 million in confidential funds. The DILG has $500 million in confidential funds. Between the two Remulla brothers, there is $1 billion in confidential funds. The Office of the President has $4.5 billion in confidential funds. Why were they not looked into? Why did Congress only look into the $125 million confidential fund of the Vice President?
$625 million.
Well, whatever it may be.
Plus
It may be $1 billion, $10
yeah.
billion, whatever the amount may be. the Constitution mandates equal protection of the laws. Persons similarly situated should be similarly treated. Why was the Vice President singled out? Number two, a lot of the contents of the articles of impeachment are, well, you know, it's pure rubbish. Like, for instance, she's being impeached because she threw a tantrum when Attorney Lopez was taken into custody. She has to
it wasn't throwing a tantrum. It was threatening the life of the president and his wife and the speaker.
That's one. That's one article. I distinctly saw the one supposedly prepared by De Lima on behalf of certain nuns that said tantrum, throwing a tantrum. Or she was being held to account for actions done when she was mayor. Those are not impeachable offenses, because when you say impeachable offense, when you say that there are certain impeachable officers, the president, the vice president, the justices of the Supreme Court, the three constitutional bodies, they should be for acts done while they were impeachable officers and not before.
As vice president,
yes,
basically.
As vice president only. So it's really, it's, you know, I remember, and I want to paraphrase one of the descriptive sayings of the late President Abraham Lincoln when there were charges hurled against him. He said that it is that those charges are as thin as the soup made from boiling the shadow of a chicken that has been starved to death. That's how thin some of those accusations are.
What do you say, attorney, to those who actually say this is the time for the vice president to actually answer the allegations hurled against her in the impeachment court?
I believe she has, in fact, answered them in an answer ad cautelam. And that is with the Senate now. The funny thing is, I don't know what game the House is playing. It would appear that they refused to receive these pleadings. Because they
defer the acceptance.
Yeah, they have tendered but not accepted. So what is up with that? They wanted her to answer. Now that she's answering, they do not want to receive it. I mean, what the heck is going on?
Oh, sorry. Okay, now I know. You were talking about what was supposedly brought to the House,
yes,
which supposedly did not have a cover letter, so they weren't really sure what that was all about. But, you know, the question really is right now is that magkakaroon ho ba ng trial o hindi? Ang tanong ko na lang po sa inyo, attorney, do you think there's going to be a trial?
Oh, your guess is as good as mine. I cannot pretend to know the sentiments of the Senate on this matter. They seem to have remanded it, and I believe we should just assume a wait-and-see attitude until after the 20th the House of Representatives of the 20th Congress certifies that they are still interested in pursuing it, notwithstanding that the 19th Congress has become functus officio.
So the questions before the Supreme Court, the petitions rather, whether the 20th Congress can continue what the 19th Congress did. Also, the petition lodged by the defense, the lawyers of Vice President Sara Duterte. Pending there is no decision, would it be better that a trial proceeds? Or is it better for the Senate to already answer the question on jurisdiction here?
I believe that since the Senate has already been constituted as an impeachment court, and it has been vested with all the powers pertinent to an impeachment court, including the implied powers to determine whether or not it has jurisdiction, which is a fundamental power of any court, even the lowest court, that when you file a case against even a metropolitan trial court, the first thing that the judge does is determine whether he or she has jurisdiction, because jurisdiction is defined as the power to hear and determine a case. And all proceedings held without jurisdiction are null and void ab initio, meaning from the beginning. So I believe that the impeachment court has the power to dismiss the case outright if there is no jurisdiction due to a fatal defect in the impeachment complaint, which is either the violation of the one-year ban or a serious challenge as to whether or not it survives the passing of the baton to the next Congress.
To the next Congress. Yeah. But you said implied, di ho ba? You used the word implied. Because if you look at Article 11 of the Constitution, it never says, it never questions or says anything about jurisdiction. It just says that the articles, once transmitted to the Senate shall form the impeachment court, and the Senate shall try and hear and decide all impeachment cases.
Well, it is a bedrock principle, Ms. Webb, that when you grant a body, anybody, even a judicial, a legislative, or even an administrative body, certain powers, the grant is expressed. It is spelled out for all to see. However, the grant of those powers carries the logical conclusion that all powers that are necessary to implement the granted powers are included in the grant. That is the case of implied power. Okay. And it is, as I've said, a bedrock principle that any court must determine jurisdiction first. Otherwise, it is futile. It would be a waste of government resources, money, time, the efforts of our senators who might be doing other legislative work to be indulging in an exercise that later on may be held to be null and void for want of jurisdiction.
But that could be also decided upon by the Supreme Court.
Definitely.
Right.
It is the ultimate arbiter if there is a challenge as to the decision of the impeachment court on the ground of grave abuse of discretion.
Very quickly, Attorney, your other client, former Congressman Arnulfo Teves, how is he? From last we heard, of course, many weeks ago, he was rushed to the hospital. We spoke that time, sir. He had to do a surgery
Yes,
immediately.
laparoscopic and appendectomy.
Okay, ano po nangyari? How is he and where is he now?
The operation was a success. However, he developed adhesions after and he was in great pain. That's why it took longer than we expected. And he was discharged last Tuesday evening, and now he's back in his jail cell. I have not talked to him since then because it's very difficult. You have to visit him personally to be able to communicate with him. So since Thursday, when I was talking to our lawyer who was with him in the hospital until today, I have not had the opportunity to communicate with him.
And when are the proceedings going to proceed? Yung trial po niya?
Hiniling po namin sana at na maging video teleconferencing lamang because we see how difficult it is for our government with its trained resources to transport him back and forth from the cell to the court and back again, because like last Tuesday, he was already discharged before lunch. However, there was no transport, no security available until late at night.
To bring him back?
To bring him back. So it took us until 8:30 or I think 9 o'clock for us to leave PGH and an hour to reach the cell. So it was very taxing for the government. So nakakaawa naman yung gobyerno kung babalik-balik siya ng ganon. Kasi ang convoy niya ang haba. 3-4 na sasakyan. May SAF. Maraming mga armado, heavily armed people. May BJMP pa. Then may protocol pa. So ang hirap po siyang i-transport. So we were asking the court, baka pwede naman po video teleconferencing naman. It will save everyone a lot of trouble. And
the reason he left was because there were threats to his life. Now he's in jail. Are there threats to his life?
There is an assessment actually by our police authorities that was given before the hearings of Congress in the Ethics Committee to the effect that he has serious threats on his life. But to the credit of our NBI and later on the BJMP, they are addressing those threats. We did not see it coming that one of those threats would be him dying of an illness because of flawed protocols that took it so long for him to be transferred to a proper hospital.
What happened to him? He was brought to the Taguig.
He was brought to the Taguig Pateros District Hospital because of protocol. Because according to protocols, he should be brought to the nearest hospital.
Yeah,
not really the
right.
most fit or the most or the best equipped hospital for that kind of illness. That's why it took several hours and we were practically pleading with the BJMP to take him to a bigger hospital because in the district hospital, they wanted to operate on him in an open surgery sort of way, which would entail greater risk than laparoscopic surgery. So, yun po, muntik, actually, now it can be told, muntik na po siyang mamatay.
All right, so now, he's safe, he's back in jail, and then naghihintay na lang po kayo ng sagot ng korte kung pwedeng video conference.
Opo. Well, some of them have already consented, but we are dealing here with 5 cases. 5 courts. So, there could be different rulings
Yeah.
from the different courts.
All right. Attorney Ferdinand Topacio, always it's a pleasure to have you. Maraming salamat po
honor
sa
is all
inyo.
mine, ma'am.
Oras. Thank you, sir. That's On Point. Join us again tomorrow, 7:30 p.m. here on BNC, the Billionaire News Channel. I'm Pinky Webb. Thank you for watching.